I'm Drew Stevenson, and this is a lecture for my professional responsibility class about the Code of Judicial Conduct. And here we're going to be giving a quick overview of some commonly tested provisions of the code to help you prepare for the MPRE. Now, for my students, keep in mind that the Code of Judicial Conduct is separate from the model rules of professional conduct for lawyers. And most of the MPRE, probably 55 out of 60 questions that you're going to have on the MPRE are going to be about the model rules. And then you'll have a few questions about the Code of Judicial Conduct. Well, the Code of Judicial Conduct is really extensive. There's it's a lot to learn for the MPRE. So what I'm hoping to do here is kind of hit some of the highlights of rule provisions that I think you're likely to see come up as test questions very quickly to give you a quick review or overview. And I'll have citations to the rule sections in the Code of Judicial Conduct in case you're confused and want to go look them up and read the code sections. So having said that, let's begin. First, this is about soliciting campaign donations. Remember that in a lot of states, judges are elected, and so they have campaigns that have to raise money. Well, the judge may not solicit donations for campaigns, whether the judge's own campaign or other political candidates, or solicit donations for other nonprofit organizations, with some minor exceptions. That's from Rule 4.1 of the Code of Judicial Conduct. By the way, this particular rule recently went up to the U.S. Supreme Court. There was a First Amendment challenge to it, and the court upheld the rule. Similarly, judges cannot engage in most political activities, right? So I know that some judges who are federal judges are appointed, but judges should not, for example, be campaigning with political candidates. Next, judges and their clerks cannot conduct their own factual research or investigation for pending cases, and this includes internet research. Now, obviously, you can do case law research. You can use Westlaw or Lexis to look up the binding precedent or the statutes that were in your case, but you can't do a Google search, let's say, to learn about the parties or study their social media history or find out about their finances or things like that on your own. Instead, in an adversarial system, the judges are supposed to let the parties do the discovery of the facts in the case and present it to the court. Next, judges can't serve on the board of directors or managers, officers, or employees of any business entity. There are minor exceptions for the judge's family business and certain nonprofit organizations. So, for example, there's a number of law schools that have a judge or one or more judges on their board of directors, or other types of nonprofits, hospitals, and so forth, but not for a for-profit company or business. Judges may not accept appointments as executors, administrators, or trustees of estates, with a very limited exception for their family members. Next, judges should not praise or criticize jurors for their verdict at the end of a trial, except in a written court order or opinion in a proceeding. Now, it's very common for judges to thank the jurors when they're being dismissed for their service. That's okay. But what the judge should not do is congratulate the jury on having the courage to rule the right way, or attack the jurors and say, "What's wrong with you people?" If you're a judge and you really, really think the jury went off the reservation, you can go ahead and do a judgment notwithstanding the verdict that will be subject to appellate review and so forth. So a written court order, basically ordering a new trial or something like that because you have a problem with the jury verdict, is okay, and that's okay, but don't attack or criticize the jurors in the courtroom. Okay, next, the judges may not make use of court premises, staff, stationery, equipment, or other resources except for incidental use for activities that concern the law, the legal system, or the administration of justice, or unless such additional use is permitted by law. This kind of goes without saying, but we don't want judges to be using the court staff and resources and copy equipment and so forth, basically to help lawyers with their firms cut costs and so on. Okay, as soon as possible after taking the bench, this is a very important rule, a judge must divest herself or himself of any investments. So that is substantial stock holdings or ownership shares in a business that could require frequent disqualification or recusal of the judge. Now, that last phrase is important, right? So we're talking about a company that's often going to be in the judge's court, so and not something that is extremely unlikely to ever get involved in litigation in the judge's jurisdiction. But the judges are supposed to divest their stock holdings for the most part when they take the bench. A judge may never serve as a character witness for anyone else in trials or other proceedings. Judges cannot use or disclose public information gleaned from their assigned cases. So, for example, you can't engage in insider trading or stock purchases based on non-public information learned while adjudicating a matter. So, for example, as a judge, you might have preliminary hearings about whether certain information is going to come in at trial. And as a judge, you learn a lot, right? You get information that the public doesn't know about, kind of behind the scenes or in court filings and so forth. And you're not allowed to use that to your advantage to make stock trades and so forth. Okay, a judge shall not abuse the prestige of judicial office or to advance the personal or economic interests of the judge, or allow others or allow others to do so. And so they give a couple of very common examples. It's improper for a judge to allude to his or her judicial status to gain favorable treatment in encounters with traffic officials. Similarly, a judge must not use judicial letterhead to gain an advantage in conducting his or her personal business. So when you're applying for to refinance your mortgage, or you go to the car dealership to buy a new car, don't ask for discounts or expect discounts because you're a judge. Okay, judges cannot accept gifts that would undermine judicial integrity. Obviously, that's going to look like a bribe, or even have the appearance of undermining judicial integrity. There are some exceptions for small token gifts like plaques and trophies. You've been such a great judge this year. Certificates, holiday gifts from relatives and friends. So it's okay. You can still do your secret Santa with your siblings. Free tickets to fundraiser banquets, other free items and discounts that could be given to anyone. But what we're worried about is the appearance of impropriety, that certain people that are going to be appearing before the judge or litigating before the judge are basically giving the judge, substantial gifts that, again, look like a bribe. Okay, although judges may not accept substantial gifts, judges can accept reasonable compensation for speaking engagements, book royalties, teaching courses, and so forth. So if you are a judge and you teach a course at a local law school as an adjunct, you can be paid for that. If you are invited to speak at an ABA conference and they pay you an honorarium, or you write a book and get royalties, all of that is okay. A judge may not be a member of any organization, such as a dining club or country club, that discriminates based on race, sex, gender, religion, national origin, ethnicity, or sexual orientation. Now, this is Rule 3.6 from the Code of Judicial Conduct. I have a whole separate video about this rule because it has some sort of tricky provisions and it's tested frequently. So you might want to watch that, but I just wanted to hit it as one of our highlights here. And I'm going to talk about two of the big exceptions to that rule in case you don't get to the other video. Membership in churches or other religious organizations is always permissible, right? So we're not telling judges they can't go to a church or temple or something like that, even though many religious groups actually have beliefs and practices that would otherwise be impermissible discrimination in other contexts, such as male-only clergy, or requirements that clergy either have to be married or can't be married, doctrinal adherence for membership eligibility. In other words, lots of religious groups will only let you be a member if you agree with their creed or their statement of faith or something like that. And so this is basically a broad exception. The other really important exception is that is the incidental attendance at an event. So judges may attend on an incidental basis an event that happens to be held in a facility of one of these discriminatory organizations. And what are we usually talking about? Dining clubs and country clubs and so forth that discriminate, as long as merely attending the event does not appear to be an endorsement of the organization's discriminatory practices. And that actually concludes our quick overview of some of the key provisions of the Code of Judicial Conduct that you really should be aware of before you take the MPRE.